Good afternoon, everybody. It's great to be back with you. It is the 13th of June, and we are nearing summer. It certainly feels like it's getting there here in New York City, where it's warm. Thank goodness the sky to my left here is not orange today, but we have clear skies after that very challenging week with air quality that we all endured around New York State, certainly for those of you tuning in. What we are here to talk about today is a set of issues that we look forward to bringing forward to your attention. I'll be giving you a bit of a recap on what's happening in New York State at the legislative level. The session maybe kind of ended. We will talk about that, and I'll walk you through where we are. Pam Silverblatt is a senior counsel here in the New York City office around the corner from me, and this will be Pam's first presentation on the program. Pam recently joined Bond, and we're grateful to have her. She will be addressing the NLRB and its general counsel and some guidance issued around non-compete agreements. Sandra Casey is back on the program. Sandra, of course, is out of our Albany office, and Sandra will be addressing U.S. Department of Education third-party servicer guidance. Mia Delane Gurley is new to our program out of our Garden City office, and we're delighted to have Mia, a senior counsel, with us on the program. She'll be addressing remote instruction for students. After that, DJ Nugent, back on the program and out of our Syracuse office, will be addressing essentially employer-sponsored employee benefit plans in the context of the end of the public health emergency. So with that, let me get started. Kathy, if you go to the next slide, please. So I mentioned that the New York State Legislature has wrapped things up in a way. I had 2 weeks ago, when I was last with you, provided some guidance around some of the bills that we were watching closely. The legislature was to officially have wrapped up its activities on June 8th. That was what was at least scheduled. Activities and debate, particularly on the assembly side, continued into this past Saturday, the 10th. And there are rumors, though presently unformalized, unsubstantiated as it were, that the legislature will come back in a period of further debate later this month to handle some of the items that did not get wrapped up. Some of them are being broadly described as more member-facing items that are specific to individual districts, but we shall see what else is addressed at that time. What didn't happen, as you can see in the marked out language on the slide, is a doubly approved, which is to say Assembly and Senate bill on data privacy. We were watching that closely, but it did not garner to House approval. The housing plan that Governor Hochul had put forward, going back to her State of the State, was ultimately, of course, removed from the budget, as we had discussed previously. Standalone legislation did not make its way to a bill that was ultimately prepared for the governor's consideration. And the speed limit restrictions that I had mentioned during my last presentation for New York City also did not go forward. What did find its way in at some level in an unexpected fashion is the New York Early Voter Act, which essentially takes a number of the flexibilities that were issued in terms of access to voting during the pandemic and codifies them on a permanent basis. I won't go into the details. We don't have that time, but certainly, we will come back with a fuller description of that if it is indeed signed into law by the governor. We're waiting on that. We don't know yet. The Clean Slate Act, I also mentioned that to you. And this is really a big one for a variety of employers across the state because, as I had described in my previous presentation, if this bill were ultimately to be signed by the governor, and now we have two different bodies, Assembly and Senate, that have approved it, it will essentially remove the records of criminal justice involvement by sealing them for individuals who have certain felonies on their records, so long as 8 years have passed, and misdemeanors 3 years. 7 years have been the initial proposal for felonies. It is now 8 in what was passed. There are indications that the governor is likely to sign this because she was involved in the negotiating, but we have yet to see that formally executed. Next slide, please. So healthcare vaccination. So here we've talked about the interplay between New York State and CMS. CMS, in the time since I last presented to you, as no doubt most of you are familiar, has rolled back its own expectations around healthcare vaccination requirements. That was on June 5th. New York State got there a little earlier, at least informally anyway, through the Dear Administrator letter that you see on the right-hand side of the slide back on May 24th. And so we will be watching essentially what the implementation of all this looks like. Vaccination is still encouraged across healthcare environments nationally as well in New York State, but the mandate is something of the past, provided that we remain in this posture where we're moving forward past the core of the pandemic. Next slide, please. And all of you, of course, are interested in what's going on with COVID-related sick leave. In the legislative packages that made their way through, nothing got to the finish line, as it were. I had mentioned in my presentation, 2 weeks ago, that there was a Senate bill, 7250, that offered promise for essentially a change in those standards. It has not really moved substantially. We'll see if that's something that is returned to at the balance of this month. I'm not certain that will happen, but we will have to wait and see. So the standards remain in place. And then remember, of course, as well, we were focused on physicians, nurses, the staffing crisis across healthcare. That remains patent. And what we also have are continuations of executive orders. There had been one I had mentioned last time. 4 had been, in its various iterations, extended out through June 8th. There is another extension now out through June 22nd. There was a bill, S7492B, that was passed by the legislature that may make some of these changes permanent. Exactly what the governor will do with it is presently uncertain. But we will be tracking all of this because we know how important it is, particularly for those in the listening audience in the healthcare and adjacent environments. Next slide, please. And finally, I'll mention that we do have confirmation of a health commissioner who is no longer acting, but officially the commissioner. That was part of the legislative activities of last week. James McDonald, Dr. McDonald, is formally confirmed and has been acting since Dr. Mary Bassett stepped down at the end of last year, early this year, right around the new year. And I remind you all that Dr. McDonald had been with Rhode Island for many years in leadership roles, but is an Albany area individual from a perspective of family and who had sought to come home and now is the commissioner. Next slide, please. Okay, great. So that brings us to the end of my remarks and my opportunity to introduce our first presenter. So as I mentioned, Pam Silverblatt is senior counsel. She comes to Bond following many years of service in and around New York City government as a key negotiator, a labor attorney who has deep experience with regard to how essentially employers position themselves vis-a-vis union relating contracts and the like. And I have the pleasure of getting to be in the same office as Pam, who's just around the corner from me. And Pam, I'm delighted to introduce you to this audience and to give everybody a chance to get to know you better and also to hear about this NLRB set of challenges to non-compete agreements. So Pam, the floor is yours. And again, welcome to the program.
Thanks, Gabe. Thanks for having me this afternoon. I'm glad to be here. I'm just going to take a brief moment and do a little bit of self-introduction in addition to your intro so that the folks out there can get to know me in my own voice. So as Gabe said, I'm Pam Silverblatt. I very recently joined Bond, probably just about 6 weeks ago. In the Labor and Employment Department. I am working principally in the higher education space. I do have experience extensively in the higher ed space in municipal government. I have done work in healthcare and I've done health benefits and for comp work as well. And I look forward to working in all of those areas here at Bond, along with my colleagues and getting to know many of you out there. I come to you this afternoon to talk a little bit about a recently issued memo put out by the General Counsel of the National Labor Relations Board. And the memo deals principally with non-compete agreements, but the implications are fairly significant because the GC's memo builds on an earlier recently issued case. And so I want to talk about the memo inside of 10 minutes, but talk about it really in a much broader context. And given that my understanding is that we've got a fairly broad audience out there, not all of our participants work in unionized environments. We've got unionized environments, we've got non-unionized environments, and employers of all different sorts. I'm going to start with just a little bit of a quick primer on labor relations and the National Labor Relations Act and how that governs labor relations in the private sector. Kathy, if we could do the next slide, please. So just real quickly, and mostly you know this and you just know it by history, and you know it because even if you're not involved with it, your friends and your family members and your colleagues are involved. So the National Labor Relations Act, as we know, was enacted in the mid to late 1930s. And the purpose of that was to encourage collective bargaining and to support labor stability and to help provide employees with a collective voice in giving them closer to equal footing in bargaining with employers, and providing some ability to have closer to equal bargaining power. So the two sections that are relevant for today's discussion are Section 7 of the National Labor Relations Act. And Section 7 of the Act, in effect, guarantees employees the rights to self-organize, that is, to form, to join, to assist in forming unions, to bargain collectively, to engage in what we call protected concerted activities. Those are all of the activities that are necessary to join together for purposes of collective bargaining. Section 7 also protects employees from refraining from engaging in those activities should they choose, except for limited purposes that are not germane to today's discussion. But Section 7 grants those protections. Section 8A1 makes it an unfair labor practice for an employer to interfere with employees in their exercise of those rights. And so those are the two pieces that really we've got to understand for today's discussion. Section 7 is granting employees the rights to engage. Section 8 makes it an unfair labor practice for an employer to interfere. Kathy, next slide, please. So the General Counsel of the National Labor Relations Board, which is the board that was created to implement and to oversee the National Labor Relations Act and to ensure that it was appropriately applied, that General Counsel of that agency issued a memo in late May dealing with non-compete agreements and providing direction to the various regions on how to interpret and deal with non-compete agreements. As we all know, non-compete agreements limit employees from accepting employment, certain jobs at the end of their employment. And the General Counsel's position is a very, very, very broad sweeping position that, except in limited circumstances, offering non-compete agreements, simply offering them, the mere offer of a non-compete agreement and enforcing a non-compete agreement violates Section 8A1 of the Act. And this is, as I said, this is kind of a broad sweeping position. And it's a reversal of where the board had been. So let's go through that a wee bit. So next slide, please, Kathy. So the reasoning behind this is that if employees know that at the end of their employment, they could be denied access to future employment, so that is, they're given a non-compete agreement, or they're offered a non-compete agreement, or their employment is conditioned on a non-compete agreement, or at some time during the course of their employment, it's conditioned on a non-compete agreement. Employees are made to understand that they will therefore have a more difficult time at the end of their employment finding subsequent employment or replacing lost income after their employment. That will have a chilling effect on their engaging in organizing activity. And that, in effect, is the General Counsel's rationale behind why the proffer of these agreements impedes employees' organizing rights. And the General Counsel's memo then cites five specific reasons or specific types of activity that would be protected under Section 7 and that the non-compete agreements impair. And those are that they concertedly threaten employees' rights to resign to demand better working conditions, and that employees would view those kind of threats as futile given the lack of access to other employment and fear of retaliatory termination, that they are threatened from carrying out concerted threats to resign, that they're threatened from concertedly seeking or accepting other employment with a local competitor to obtain better working conditions, that they are impeded from soliciting co-workers to work for a local competitor, same kind of rationale, or that they're impeded from seeking employment to specifically engage in protected activity with others at an employer's workplace. And, the rationale behind all of those is really the same, that they have a chilling effect on an employee's ability or willingness to engage in concerted activity. Next slide, Kathy, please. So what's really important to know is that notwithstanding the broad brush of the memo, the General Counsel carves out the position saying that not all non-compete agreements are illegal. So that, for example, the General Counsel preserves a position that narrowly tailored non-compete provisions could be deemed legal. So, for example, provisions that protect proprietary information and trade secrets, provisions that restrict an individual's managerial or ownership interest in competing businesses, provisions that protect true independent contractor interests may constitute lawful non-compete agreements. So those very, very, very narrowly drawn provisions may be deemed legal. However, the following examples are unlikely to ever justify non-compete agreements: a desire to avoid competition from former employees, which is frequently the reason that you see a non-compete agreement, or an interest in retaining employees or protecting investments that were made in training employees. So those two examples are likely to ever justify a non-compete agreement. The reason that, next slide, Kathy, please. This is particularly of note is that the memo, although not binding law, provides direction, as I said earlier, to the many NLRB offices around the country that investigate and prosecute unfair labor practice charges. And so, in effect, what the General Counsel is saying to all of the offices across the country is, I want you to be looking at and looking for these kinds of matters and these kinds of cases. And I want you looking to see where, and this is the quote, to seek make-whole relief for employees who, because of their employer's unlawful maintenance of overbroad non-compete provisions, can demonstrate that they lost opportunities for other employment even absent additional conduct by the employer to enforce the provision. So really, the general counsel is directing, I would say, directing the regions to look for cases where there are overbroad non-compete agreements and to move those cases forward. Now, in and of itself, that might give us pause, but we might have limited pause where I think there's a multiplier of concern, and I would underscore for employers out there, you need to have particular concern is, and I'm going to ask you, Kathy, to skip ahead if you wouldn't mind. Where I would ask you to have particular concern is that this memo was issued on the heels of an NLRB case that came out in February of 2023. And the case is called McLaren-Macomb, and that had to do with a unionized teaching hospital in Michigan that furloughed 11 union employees. And in that case, there was severance agreements offered to the furloughed employees. And those severance agreements contained confidentiality provisions and non-disparagement provisions. And in effect, the NLRB in that case found that the non-disparagement provisions were overly broad and that the confidentiality provisions similarly were overly broad. And the arguments in McLaren were that the agreement is unlawful if its terms have a reasonable tendency to interfere with, restrain, or coerce employees in the exercise of their Section 7 rights. And the non-disparagement provisions were problematic in that the employee's ability to discuss the workplace, the breadth of that provision was too broad. There was no time limitation. And so those provisions were, for a series of reasons, similarly deemed to be too broad. And so when you look at McLaren-Macomb, where the non-disparagement focus was on the fact that public statements and employees' ability to make public statements are central to their exercise of rights under the NLRB, and that the employer's limitation of that the limitations placed in the severance agreements with respect to it's really about the fact that the limitations placed with respect to employee speech in terms of non-disparagement and confidentiality are substantially being curtailed there. And so the issues there, as well as in the general counsel's memo, go to the same kind of issues, and that employers have to be very careful and very judicious in drafting language, in drafting provisions, and in drafting agreements that go to curtailing employees' attempts to speak and freely speak and try to maintain employee confidentiality post-employment. And that really is the larger issue, and the larger message is that as employers, you need to be very careful and very judicious in crafting agreements and provisions that go to eliminate employees' post-employment speech and job seeking. I'm giving it back to you, Gabe.
It's terrific to learn from you, Pam. Thank you so much for taking this time, and the group will have an opportunity, I'm confident, to continue to learn from you on future programs. And obviously, this is scratching the surface of a complex topic. I remind the group that you've also issued some written guidance along with co-authors at the firm, including Tom Aaron, around these issues. And so please, as a group, we ask the audience to stay tuned for more from Pam on this and related matters. So with that, let me shift to our next speaker for the afternoon. And thank you, Pam. That's Sandra Casey, who is senior counsel out of our Albany office and is an attorney focused on higher education with deep experience as general counsel as well. Otherwise, great familiarity with activities of state and federal departments of education. And we're here today to learn from Sandra about the U.S. Department of Education's guidance on third-party servicers. So Sandra, the floor is yours. Thank you for coming back on the program. I very much look forward to your presentation. I'm confident the audience does as well.
Thank you, Dave. Thank you, everyone. It's good to be here with you today. It's been a long time since I've spoken, so it's nice to be back. And I'm going to be presenting on an exciting topic of third-party services. So next slide, please. So entities that fall under the definition of a third-party servicer are subject to the U.S. Department of Education's oversight and must abide by specified rules. And institutions have long been required to ensure that their agreements with third-party servicers.
Sandra, I'm sorry to interrupt you, but your audio is cutting in and out. If you could just find your way a little bit closer to the mic, I think that would help. Thank you very much.
How is this? Is this better?
That is vastly improved. Thank you.
Oh, okay, I think I'm shifting too much. Okay, I apologize. So historically, these obligations have been limited to vendors assisting institutions with core Title IV administrative functions, such as processing student financial aid applications, originating loans, and loan collection services. Next slide, please. The Higher Education Act defines a third-party servicer as any individual, state, private, for-profit, or nonprofit organization which enters into a contract with an institution to administer any aspect of the school's student assistance programs. In its regulations, the department interprets this definition of third-party servicer to include those that perform functions related to any aspect of the school's participation in Title IV programs. Now, to me, this is much broader than the statute because a school's participation in Title IV programs is very broad. It includes things like Title IX compliance, Clery Act compliance, and so schools that outsource these type of obligations have to be concerned about whether those vendors who are performing the functions fall under third-party service rules. Next slide, please. So here I offer the definition of third-party servicer that's actually in the Department of Education's regulation. And in addition to their definition, the department provides examples of what they consider third-party servicer functions. And you'll note that most of these are typical core Title IV functions. Next slide, please. And also in the regulation, the department states what is not considered a third-party servicer function. And I've highlighted for you providing computer services or software, which will be relevant later in my discussion. Next slide, please. So over the past several years, the department has issued Dear Colleague letters on third-party services to provide guidance on the type of vendors that would be subject to third-party servicer regulatory oversight. So over the years, they've expanded what they consider to be third-party functions in these Dear Colleague letters. So this is significant, with regard to the department expanding what they consider a third-party service function. So they include things like student recruitment and retention services, consumer disclosure activities. So again, any type of relationship a school has with this type of outside vendor may bring that outside vendor into the orbit of third-party servicer rules. So, and the third-party servicer rules require that the institution in its contract with the third-party servicer require that that servicer be jointly and severally liable along with the institution for any Title IV violation resulting from the functions that they perform. Also, the third-party servicer must be required by contract to maintain appropriate safeguards to protect any consumer data that the institution provides to them. They're also subject to audit requirements. Next slide, please. So on February 15th of this year, the department issued Dear Colleague Letter 2303, mainly to address issues concerning online program managers or OPMs. OPMs have proliferated in the past several years. And typically, they provide online course instruction to students, and they help schools with retention and recruitment of students. And they're paid substantially by the institution for the service. So this has raised the attention of consumer advocates and also the federal government. The Government Accountability Office issued a report last year on OPMs and warned the department, although they're not nefarious or pernicious, the accounting office basically told the department, you really need to provide better oversight of these OPM relationships. And also certain members of Congress sent a letter to the Department of Education back in December and said, how are you going to respond to this report by GAO? And what are you going to do to regulate OPMs in the future? So as a consequence, in response, partially, the department issued this February guidance and brought into the third-party services orbit the provision of software products and services involving Title IV administration. And as I highlighted before, those typical computer services were exempt from the definition of third-party services. So this is significant, update and development. And also, the new guidance, the February guidance, basically brought in educational content and instruction as a third-party servicer function. Now, this caused great consternation among the higher ed community because of all the relationships that institutions of higher education have with each other on course sharing and course instruction, and also the relationships they have with high schools and local education agencies on course instruction and content. So the department stated that the new guidance was to be effective May 1st, 2023, and people were just like, oh my gosh, how are we going to comply with this? However, the department quickly revised the effective date to September 1st, 2023. Next slide, please. So the department received over 1,000 comments to the Dear Colleague letter, Gen 2303, and as a result issued a blog post on April 11th to clarify the types of functions that would not fall under third-party servicer rules, and also to delay the effective date of compliance. The department then issued a Dear Colleague letter, Gen 2308, on May 16th that rescinded the September 1st, 2023 effective date indefinitely and stated that any further effective date would be at least 6 months following a final Dear Colleague letter on third-party services. The Dear Colleague letter issued on May 16th also withdrew the department's prohibition for preventing institutions from contracting with foreign entities. The original prohibition appeared in an earlier Dear Colleague letter, which language the department rescinded on May 16th. However, the department cautioned there may be further oversight in this area as a result of negotiated rulemaking in the future. So we may see this prohibition come back. Next slide, please. So as I mentioned, the department issued that April 11th, 2023 blog post, and they put in that blog post, and I won't read it in the interest of time, they put in that blog post, it's very important, things that they don't consider to be third-party servicer relationships. And, one of them is study abroad programs and those course sharing arrangements that I mentioned before between institutions. And any kind of clinical or externship opportunities are also not considered third-party servicer functions. Next slide, please. So in conclusion, although the updated guidance on third-party servicers is now delayed, institutions are really encouraged to review their relationships with third-party vendors in light of 2303 Dear Colleague letter, as revised by the May 16th guidance and is clarified by the April 11th blog post. This will allow institutions not only to identify quickly those contracts that will most likely be considered third-party servicer agreements under updated guidance, such as agreements with OPMs, those really should be front and center for any review, but will also afford adequate opportunity for institutions to discuss applicable contract requirements with third-party vendors. So hopefully that's occurring right now. So thank you, Gabe. Thank you for your time. Good luck, everybody.
Thank you very much, Sandra. And to the audience, apologies for the audio issues, but Sandra's slides will be absolutely available on our website after the presentation if there's anything you missed. I'm going to quickly move to our third speaker, who is Mia Delane-Gurley, who I noted is out of our Garden City office and who has a long career in education law, including many years working in New York City's education department, and brings that experience to Bond. So Mia, we look forward to learning from you. Thank you for joining the program, and hopeful this is the first of a number of appearances forthcoming, and I'm really glad you can make this time.
Thank you, Gabe. Happy to be here. Good afternoon, everyone. Today, I wanted to spend time discussing remote instruction. As we know, remote instruction is a form of instruction that's known to all districts throughout New York State and throughout the country. What I want to do today is highlight those areas in the law where remote instruction is referenced. So you may or may not know that remote instruction is now defined in the Commissioner's regulations to mean instruction provided by an appropriately certified teacher, or in the case of a charter school, an otherwise qualified teacher pursuant to Education Law 2854, subsection 3, subsection A1, who is not in the same physical location in person as the student receiving the instruction, where there is regular and substantive daily interaction between the student and teacher. The importance of the definition here in section 100.1 of the Commissioner's regulations is that it gives schools and school districts some clarity with what remote instruction is exactly. What's next important in the regulations is how, in fact, remote instruction is to be delivered. So the regulations, again, it was section 100.1, subsection U, subsection 1, 2, and subsection V, say that remote instruction should encompass synchronous instruction provided through digital, video-based technology, and may also include asynchronous instruction intended to complement synchronous instruction. Digital, video-based technology also includes online technology and video conferencing technology. Remote instruction may also encompass non-digital and audio-based asynchronous and/or synchronous instruction where such instruction is more appropriate for students' educational needs. The non-digital and audio-based instruction that I referenced means instruction accessed synchronously or asynchronously through paper-based materials where the student-to-teacher interaction occurs via telephone or other audio platforms. Another question that comes up when you're discussing remote instruction is when can it actually be utilized now that the pandemic has receded? So for students with IEPs, remote instruction can be utilized when their IEP identifies the need for remote instruction to provide a free and appropriate public education, or FAPE. It can also be utilized for all students in the case of an emergency closure, including but not limited to extraordinary adverse weather conditions, impairment of heating facilities, insufficiency of water supply, shortage of fuel, destruction of a school building, or a communicable disease outbreak. The importance for students with disabilities in terms of providing it when their IEP references it is because there's a specific regulation on this point, specifically section 200.4 of the Commissioner's regulations, subsection E7, which indicates that you're required to provide special education and related services in accordance with the student's IEP. So when remote instruction is going to be the modality for that instruction, it should be contained within the student's IEP. I'm going to briefly get into shortly the emergency closure provision, which is now codified in section 175.5, subsection E1 of the Commissioner's regulations. To first start with students with disabilities and the provision of remote instruction, it's important to just have some considerations in mind. Specifically, will the method of delivering remote instruction enable the student to receive a free and appropriate public education? Is the recommended remote instruction individually tailored to the student's unique needs? Will the recommended remote instruction provide the student with access to recommended services that would allow the student to progress towards their IEP goals? And have you as a district considered accessibility issues? For example, the student's ability to use technology, the student's access to the internet, a telephone, or other audio platform. So now the emergency regulations. Section 175.5 of the Commissioner's Regulations was amended to codify the previously authorized Snow Day pilot program, which allowed school districts to deliver instruction remotely on days in which it would otherwise have closed due to an emergency. With this amendment, districts that would otherwise close due to an emergency may, but are not required to remain in session and provide instruction through remote learning and count these instructional days towards the annual hours requirement for state aid purposes. Again, an emergency closure includes but is not limited to extraordinary adverse weather conditions, impairment of heating facilities, insufficiency of water supply, shortage of fuel, destruction of school building, or communicable disease outbreak. There's been another recent amendment to Section 155.17 of the Commissioner Regulations, which now requires every Board of Education of a school district, every Board of Cooperative Educational Services, or BOCES, and county vocational education and extension boards, including the New York City Department of Education, to add emergency remote instruction provisions to their annual district-wide school safety plan. Beginning with the 23-24 school year, all public school districts and BOCES must develop a plan that addresses 6 different regulatory components related to how they will provide remote instruction under emergency conditions. Emergency remote instruction plans must include the methods by which districts and BOCES will ensure the availability of devices and internet access, provision of special education and related services for students with disabilities, and the expectations for time spent in different modalities should an emergency require the district to transition to remote instructions. These plans are required for all public school districts and BOCES, even if the entity does not intend to utilize the available regulatory flexibility to provide remote instruction on days when the school or district would otherwise close due to an emergency, and count these instructional days towards minimum requirements. The goal of these plans is to ensure that there is a common understanding about remote instruction amongst district or BOCES staff, teachers, families, and students. I want to thank you for your time again. I just wanted to highlight those remote instruction provisions for you and all school districts working with students and families. Thank you for your time today.
Mia, thank you very much. And Mia is certainly available to any of you who has a question and follow-up. Mia, thank you for joining the program, and please come on back. And let's turn to our last presenter for the day, who is DJ Nugent, who has been on our program a number of times before, and is going to talk to us from the Syracuse office about essentially benefit relating matters in the context of the end of the PHE. We'll keep it brief. We know we're right at the line of timing here, and we thank you for indulging us a few minutes extra today. DJ, the floor is yours.
Gabe, thank you so much, and I will do my best to keep this concise and succinct. So what I'm going to talk about today, and hopefully this is not news to anyone, is the impact of the official end of the COVID-19 national emergency period and the associated outbreak period. Next slide, please, Kathy. I've laid out on this slide really the timeline. Again, hopefully this is not news to anyone, but on March 13th of 2020, the COVID-19 national emergency was declared by then President Trump. And in April of that year, a final rule was issued jointly by the United States Department of Labor and the Department of Treasury that we refer to as the Joint Notice. And what the Joint Notice did was require that the period from March 1, 2020 until 60 days after the announced end of the national emergency, which is referred to as the outbreak period, be disregarded for certain employee benefit plan deadlines. And I put those plan deadlines on a subsequent slide. They mostly apply to health and welfare plans, but they do apply to retirement plans as well. There's quite a few bullet points of what those deadlines are, but they really can fall into several broad buckets: COBRA deadlines, claims and appeals deadlines, and HIPAA special enrollment plan deadlines. I'm sure many of you are on the call have been aware of this and the administrative burdens and hassles that those told deadlines have created as you try and administer your plans. In 2021, EBSA, which is a function of the United States Department of Labor, clarified when those deadlines end and that it applies on an individualized basis. That brings us into 2023. In January of this year, President Biden announced his intent to end the national emergency on May 11th, 2023. Following that announcement in March, the DOL and IRS issued FAQs providing hypotheticals and very helpful information on how plan administrators should administrate the end of the outbreak period and those deadlines that had been told and how they are no longer being told. As part of those FAQs, the DOL and IRS assumed that the outbreak period would end on July 10, 2023, which is 60 days from what was then the intended end of the national emergency period. Interestingly, on April 10th of this year, President Biden signed HJ Res 7 into law. On April 10th, that signature into law ended the national emergency period effective immediately. That did create some confusion as to when deadlines would actually be told until. There's not been any firm, formal statements from the IRS and DOL. However, there's been quite a few sources that have reported that there have been informal statements from the agencies that even though 60 days from April 10th would be earlier than July 10th, that the IRS and DOL are going to apply the dates that were in their FAQs issued in March. So that was very helpful information to know that, okay, they provided these helpful FAQs. We can actually go off the dates that they include in those FAQs. Next slide, please, Kathy. This slide is just the deadlines that were extended as part of the outbreak period. Again, they fall broadly within the COBRA claims administration and HIPAA special enrollment claims categories. In short, as many of us know, really what it did was complicate plan administration. Next slide, please, Kathy. This helpful notice that was issued in 2021 clarified the time period that deadlines were told until. When the joint notice was initially issued in 2020, some commentators thought, well, okay, if I was supposed to make a COBRA election in March of 2020, would I have until 60 days after the end of the national emergency period, in this instance, 2023, to make a COBRA election? Essentially, I could make a COBRA election 3 years from the date that I was initially supposed to make it, retroactively elect COBRA, retroactively pay for it, and that 3-year period we would need to essentially do a look back to see what coverage individuals would need to get under COBRA. What this EBSA notice said is that deadlines apply on an individualized basis and are extended until the earlier of 60 days after the announced end of the national emergency, or 1 year from the deadline that would have applied not for the national emergency. Taking a COBRA election deadline example, that would mean if an individual needed to make their COBRA election by February of 2022, they would have until February of 2023 to make that COBRA election. They would then retroactively elect February of 2022. If they made their retroactive COBRA premium payments, they could get COBRA starting in February of 2022 through whatever deadlines they have under COBRA. Next slide, please, Kathy. Again, because of this retroactive, and I'm taking COBRA just as an example, but there were other categories as well. As part of this retroactive application of COBRA special enrollment claims, it was an administrative burden for plan sponsors and their administrators to keep track of when people were making the elections, were the elections timely, and how to administer those retroactive elections. That has now come to an end. So under the DOL and IRS FAQs, they provide very helpful guidance using that May 10 deadline and pushing it out 60 days to July 10. Quite a few different hypotheticals in there that can address possible situations that come up. I've just put 2 of the examples on this page that provide some illustration of what the DOL and IRS do. So in the first example, individual A works for an employer and participates in the employer's group health plan, and individual A has a qualifying event for COBRA purposes and loses coverage on May 12th of 2023, would need to make their COBRA election on May 15th of 2023. Because the qualifying event occurs after the end of the COVID-19 national emergency, but during the outbreak period, the extensions under the emergency relief notices still apply, and the last day for that individual's COBRA election period is 60 days after July 10, 2023, which is September 8th, 2023. Example 2 on this page looks at an individual who needs to make their COBRA election after the end of the outbreak period. Now, you'll note that this individual needs to make their COBRA election 2 months after the individual in example 1, but only has 5 more days after the example in individual 1 in the first example to make that COBRA election. So that's really talking about the distinction of somebody whose COBRA election came up within the national emergency period and outbreak period, and someone whose COBRA election comes up outside of the COVID-19 national emergency and outbreak period. Next slide, please, Kathy. A lot of information there, very quickly provided in a nutshell. The real takeaways are to be aware that the outbreak period is going to end. It's been announced that it's ending. Be aware that there are very helpful FAQs issued by the DOL and IRS, and that those deadlines in the FAQs will still stand, and that employers, you should make sure to talk with your plan administrators, insurers, to make sure that any steps that need to be taken are taken, that any communications are being revised, so that those deadlines are accurately reflected, that they're ending, and on a go-forward basis that you have the correct deadlines in those communications. So with that, I really appreciate your time, and I appreciate you understanding the quick delivery, and I'll hand it back over to Gabe.
DJ, thank you very much for being so respectful of the audience's time and otherwise. We thank all of you who have stuck with us a few extra minutes. DJ, you were always welcome back on the program, and we thank you for what you had to share today. If anyone has questions around what was presented, the contact information for each of the presenters is up there on the slide that Kathy has just put in your view. So thank you, Kathy. I will be back with you in 2 weeks' time. Kristen will be your host next week. And in the interim, wishing you all a terrific end of spring as we glimpse ahead towards summer. Very exciting, and we look forward to being with you throughout the summer months ahead.